Good afternoon, everyone. Thank you for joining us for our next iteration of the HospitalityLawyer.com virtual seminar. Today's topic is risk management and loss prevention, produced by HospitalityLawyer.com. Today is July 26, 2022. It's 11 a.m. Central Time. Before we get started with today's topics, we'd like to remind you about a couple of our events coming up. Continuing our virtual seminar series, we'll have legal challenges in contract food service management. That will be Tuesday, November 15th at 11 a.m. Central Time. And then, of course, our second face-to-face program this year, our 2022 Hospitality Law Conference, the Hospitality Law Conference, Washington, D.C., Wednesday, October 12th, at the fabulous Army-Navy Country Club in Arlington, Virginia. This is a one-day program. We hope you can join us there. So we'd like to thank our co-producers for this program, Global Guardian and the Hamilton Miller Birthisel law firm. Thank you both. So to get us started today, our first topic, risk management, mitigating security and crime risk, plus post-incident investigations. Our speaker this morning is Mr. Derrick Kelly. Derrick is a partner in the Hamilton Miller law firm out of Miami, Florida, but they have a national and quite often international practice because they do a lot of litigation in the Caribbean, in and around the Caribbean. Derrick is an experienced litigator in lots of different areas of litigation, including negligent security. His practice focuses on insurance and business defense, and he is highly acclaimed as an instructor with the National Institute of Trial Advocacy. Welcome, Derrick.
Thank you. Thank you, Stephen.
It's great to have you with us, as always, to have somebody from your tremendous law firm. We've had a long-standing relationship with you guys, and everybody just provides great insight. So we're really looking forward to your remarks. So, Derrick, to get us started, just so that everybody's on the same page, because our audience consists of lawyers, senior risk folks, but also some operators. Can you start us off by just giving us what you believe to be a good definition of risk on this next slide?
Sure. So thank you, Stephen. Risk can be defined in many ways, but what we try to do is keep it as broad as possible so that it can encompass as much as possible. As you indicated, this is a diverse audience, and we want to make sure that everyone is covered. So just generally, broadly speaking, a risk is a potential or future event that, if it should occur, results in harm or loss that can have a negative impact on an organization. So as you can see, that definition is not incident specific, it's not establishment specific or organization specific, but it is broad enough to make sure that everyone understands when we're talking about a risk, we're really just talking about an event, and we don't know what that event could be because every organization is different and the events that affect them are different. But should that event become an incident, it certainly can have a negative impact on an organization in a number of ways, and we'll discuss those going forward.
Yeah, if we look at this next slide, you've laid out for us, first of all, it's very important, I think, that everybody understand when we're talking about risk, we're talking about, as you point out, both to potential harm to both people and property, right? That's crucial. And then you've also laid out for us the different perspectives that risk, these harms can impact. And so, ladies and gentlemen, he's really done us a great service by suggesting some questions that we should ask ourselves in these particular areas. And we've highlighted those for you, and we commend them to your reading at another time because our time is short this morning. But just to pick out a few, Derrick, as you pointed out, when that crime risk actually materializes, right? It can really affect an organization in a number of ways. You've identified the customer perspective, the worker perspective, the public's perspective. Visit with us a little bit about that, if you don't mind.
Sure. Well, I won't highlight all of the questions, but just to think a little bit about, and this is something that people really don't think about as often, but let's just talk about employee morale and worker productivity, because that's something that is not addressed as often when you think about what happens when a crime risk becomes an actual crime incident. Often when we go and I investigate cases of negligent security in establishments after they happen, the one thing you'll find out is that there's often a negative perception of the organization from employees, especially when employees believe that something might have been preventable or if it just wasn't addressed and ignored. And you get questions like that. Do they care, or is this job worth it? Now, from an operational perspective, you think about those things later on. What kind of people I want working for my business? What kind of people I want in my organization? But those questions do come up. And if you have good folks that are working for you, doing a great job, they may be negatively influenced when these things happen and want to leave. And what happens when good people leave? Well, productivity diminishes, and the quality of service that you can provide your patrons diminishes as well. So those are some of the questions I think you really should ask yourself from the employee perspective. How are my employees and the people that work in my organization perceiving this event as well, as opposed to just moving on with it? So those are some of the things that are not as thought about as much. And that's not so much from a case perspective, as much as it's also from a post-incident investigation perspective, when I have to go out to organizations and prep employees for depositions or just doing fact-finding interviews. And these are some of the things that you hear from them. And in the end, operationally, it certainly can affect your business.
Oh, that's for sure. And I just want to emphasize your point. My experience, having participated with the industry for a long, long time, when those good people start to leave, other good people will follow them because good people want to work with good people. And if you lose your good people, you're only left with your not so good people. And that's, none of us want to be left in that situation. So let's look at this next slide, Derrick. And you've done something very interesting. I love this dial image that you have here on the left-hand side. And I just want to walk through those four aspects very quickly with you, if you don't mind. So first of all, we can transfer risk. And that's, I assume, we talk about insuring risk, right? Or we transfer the risk by insurance, or we can transfer it through indemnification. Are there other ways, or have we covered that?
No, and I think that's the predominant way in the field, that is transferring it through some type of agreement. Anytime you hire someone else to do something, for instance, if you hire a security company to provide services, there generally be some type of indemnification agreement that transfers the results of risk gone bad, so to speak. The law may not necessarily recognize them as being responsible. You may ultimately be the organization that's on the verdict form, and maybe the court may decide they're your subcontractor. We're not going to relieve you of any non-delegable duty, but certainly you are transferring the financial consequences of a risk gone bad.
Yeah, and I think that's a great point. I tell you, my experience, Derrick, is that oftentimes when I'm negotiating agreements or contracts, a lot of times businesses leave it to line level folks to negotiate these things. And I find that very rarely do people really understand the meaning of indemnification, right? They don't understand the impact that it could have on an organization. We don't have enough time to discuss that today, but I think the takeaway for those on the call is that anytime your organization is going to indemnify somebody, that you need to be really cautious about that and make sure you're understanding the risks that you're undertaking. Derrick, I'm sure in your litigation practice, there have been some people surprised at what that indemnification clause ended up costing them.
They did, and I will just make a quick observation. If you are the establishment that hires a independent contractor to provide a service, and then you include an indemnification and agreement, one of the things you have to be careful about is what I call reciprocal indemnification requirements, because oftentimes we get in cases where people think that their indemnification clauses are strong, only to find out that there is some nuanced reciprocal indemnification that excludes any responsibility if there is at least another cause possible. So let's say, for instance, you have a security company, and that security company is supposed to provide services. And one of the theories is that the security company did not provide the services they were supposed to. Fine. But then what happens if the plaintiff has another theory that besides the fact that the security company didn't provide services, you did not properly secure another area of your establishment with something that's totally unrelated to a security guard? Well, what does that company do? Well, now you have competing theories of liability, competing theories of responsibility between the parties. And so what you thought was an ironclad indemnification clause may not be as ironclad depending on the theories a plaintiff raises in the case. So those are things you really have to be conscientious about and try to make it as broad as possible.
Yeah, that's for sure. That's a great point. And if I can follow up, just one thought that I run into all the time is people think, well, I'm indemnified, but an indemnity is only as good as the money behind it. Is that a fair way to put it?
Correct. It is. If you have a $10 million, demand and the indemnification, and I would tell you the one thing too is making sure that the company that is indemnifying you is going to produce the necessary insurance to cover you up to a certain potential for the risk. So you don't want to have a situation where the company, and we see this all the time, you have an independent contractor that has insurance, but they have specialty insurance, right? It's not the best insurance. They're not necessarily the most insurable risk. And so all of a sudden they have to get policies from insurers that put lots of exclusions and conditions in the policy. And the next thing you know, you're seeking indemnification and you realize, wait a minute, the thing that they're supposed to do, well, they really don't have more than $1 million. And so that's where I'm capped, but this is a case more than $1 million. And besides that, even if they did have more than $1 million of coverage, I'm running into a specialty form policy that has a plethora of exclusions that limit the amount that I can essentially transfer for a risk gone bad. So those are things you have to think about as well.
Yeah, and that's crucial information, especially for those that are on the program today. From the compliance perspective, it's not enough to be sure that the policy is in place. You've got to verify that you have the coverages that you believe you're being indemnified for. Derrick, that's just a great point. Okay, well, we can transfer, we can accept, we can avoid, and then we mitigate, which is what we're focusing on today a lot of, but I think that conversation we just had was very helpful. So let's look at this next slide where you talk about, it may not reduce the desire to commit the crime, but it can reduce the ability and opportunity to commit the crime. And that's what mitigation is essentially achieving for us. Is that correct?
That's correct. And so just to kind of give you a little bit of background also, I was in law enforcement for many years before I became a lawyer. I was a major crimes detective investigating a lot of cases of violent crimes, especially against children, as well as robberies and homicides. And one thing that we know in that law enforcement perspective is that really there is no way to reduce the desire to commit crime. Criminals are always looking for ways around the system, right? So you'll never eliminate the desire because the desire to commit the crime is internal. But what we're talking about in mitigation is trying to reduce the ability and the opportunity to commit the crime. Are we doing things that discourage or dissuade the criminal from acting on their desire? And I will say that that just depends on circumstances. Every crime is different. So there's always going to be some outliers, but it's just the idea of recognizing that you're not going to change people's minds, right? You have to focus your mitigation efforts on trying to limit the ability and the opportunity. And that's where most of your work, that's where the hard work is essentially, Stephen. and trying to put together mitigation strategies that target those two things, ability and opportunity. And we'll leave the clergy and everybody else to the desire.
Well, that's good. And so on this next slide, it begs the question, can we eliminate all risk?
No, we can't. And mitigation by itself is just lessening it, but it's not eliminating it. And as I indicated in the next part of that slide, in a nutshell, the ultimate goal is to reduce the risk of harm of loss in reasonable and responsible ways that earn customer appreciation and worker engagement. I think it's important I finish that statement with those two things, because ultimately that's the why we want to mitigate. We want to make sure that your patrons, and no matter what establishment you have, can appreciate what you've done to reduce that harm of risk or loss. And then also you want to make sure that your team members are part of that strategy. So no, we can't eliminate it, but these strategies are certainly designed to reduce it or lessen it as much as possible. Hence, that's what we're trying to do when we mitigate the risk.
That's very insightful. Thanks for that. Ladies and gentlemen, before we go on to this next slide, I want to remind everyone that you can submit questions via the chat, please. The chat is a little easier to facilitate. So if you do have a question for Derrick, please submit it via the chat. So Derrick, let's look at this next slide, because listen, whenever it can be a daunting task to mitigate risk, but you've reached out to a thought leader who shared with us two really important aspects, I think, to just get us started, right? What's the old adage about how do you eat an elephant? One bite at a time, right? And so, the situational awareness, as we're going to see in some of the cases you brought to us for this program, as we'll see about how important situational awareness is and different circumstances are. But once we've kind of made that awareness assessment, then we have to prioritize that mitigation execution, right? Talk to us a little bit about that. How do we go about that? What's from your law enforcement background and your professional legal background, where do you suggest we begin?
Sure. Well, I just want to let you know this actual these thoughts actually come from an assessment about compliance, and it's interesting because it actually comes from an assessment about compliance within an organization, ensure that it makes sure that it's compliant with applicable laws. It's almost from the financial side, but I brought it here because oftentimes we don't think about the prioritization, right? So we'll talk a little bit more about the situational awareness, things that affect that, but prioritization of mitigation execution is so important because you want to make sure that you're putting your best foot forward in the things that are going to impact your organization the most, right? And that varies from organization to organization to organization. What may affect one organization because of the way it's located? What may affect a lodging establishment may be different from what affects a food service establishment. So prioritizing the mitigation execution is making sure that we are putting our best foot forward and using strategies that are going to have the biggest impact, and not simply just spinning our wheels and time throwing things at it for appearance sake that ultimately don't help protect the organization and its consumers as much as it can.
Yeah, that's very good insight. Okay, on this next slide, Derrick has provided you with some key questions you should ask when you're trying to develop that situational awareness. And Derrick, in the interest of time, we're going to commend that to their reading. And then I'd like to go on to this next slide, because we're really getting into some of the real challenges that businesses are facing today. And it begins, this is a 1981 case out of Florida, but it really establishes kind of that standard of ordinary care. Do you agree?
Yes, it does. And even though it's a 1981 case, you can get newer cases, but these are what we call seminal cases that have been followed and cited and use as references for later appellate cases. And I think it's good sometimes to go to the source and understand the reasoning behind. And you'll notice one thing in this case, if you skip down 3 sentences, as to the degree of care that an innkeeper, and let's use that as much as possible, that's not simply an innkeeper, but as an organization.
Right. So it could be an innkeeper, could be a restaurant. Yeah, it could be. Yeah, right.
That will vary in relationship to the attendant circumstances. And I can't emphasize that enough, that it is not a one size fits all approach. And this is why mitigation efforts are never a one size fits all approach. That observation in terms of what that care is going to depend on the circumstances in relationship to that organization. And those are things that we discuss later. But that is an important observation that the appellate court made that I think any organization should keep in mind. It's not one size fits all, but it's going to be based on what's unique to your organization and your business.
Yeah, I think that's very helpful. Derrick, I'm fond of saying that businesses in the United States, including lodging and food and beverage businesses, we are not the insurers of our guest safety, but, and it's a big but, we have a duty to operate with reasonable care and to reduce, mitigate the risk of foreseeable, harms. Do you agree with that? You feel like we're on the same page?
Absolutely. And again, the case itself just sets out generally, and for your sake, I didn't want to just read what was there in entirety, but just to point out. But again, if you think about that, whether you're in food and beverage, whether you're in lodging, as the court noted, the standard of care, say in this case, in providing security, will be vary according to the particular circumstances and location, and then that sort of determines to what extent, what duty you owe your customer, what duty you owe them. And so that segues into, I'm not an insurer of risk, right? I'm not an insurer per se of their safety, but depending on those attendant circumstances, I may owe my customer a little bit more because of this than that. Yeah. And that's the one thing you have to keep in mind.
Very good distinction. Okay, well now, as we all know, right, when we went to law school, we all had that case, those of us that are lawyers, we had that case that said the first dog bite is basically free, right? Because that puts you on notice that the dog could bite, right? And before that, you didn't know it. And Derrick, I know you've handled lots of these cases. Typically, plaintiffs' lawyers like to demonstrate that there were previous crimes in and around the location where a crime occurred, and that makes it foreseeable, right? And adds that burden that you just talked about as the circumstances change. But here's the question, because I think everybody would like to know: is no prior crime a defense? Is it still a defense? I'm not sure it is. And from one of your slides coming up, and we'll look at it right now, I'm not sure we can say that.
Well, here's what we can say. We can always argue that no prior crime in relationship to the one that caused litigation as a defense. But just blanketly saying that there was no prior crime as a defense, it's one you can make, but the degrees to which it's going to be successful will vary. And as we move to some of the other slides, just to go on that, think about it this way. Even if there is no prior crime per se, that is, no documented crime, was there something that existed prior to your incident that would have put you on notice that a crime like the one that occurred could exist? So no longer is it simply a blanket, no prior crime. Now what they're looking at is no prior awareness. And so those are completely different things that we'll discuss going forward.
Yeah, let's look at this next slide, because it's exactly what you're talking about. Now, this is an excerpt. He's given us an excerpt from a program that's built for the plaintiff's bar, the trial attorneys, and how they're trying to create a pathway to recover in a case where we don't necessarily have prior criminal acts. Is that a fair recitation of what's there, Derrick?
It is, and I intentionally picked this article. It's a 1997 article in the state of Missouri Bar. And the reason I picked this article is to show you that 25 years ago, almost 25 years ago, this was the thought process of very skilled plaintiffs lawyers even then. Let's not restrict ourselves to trying to look for cases where there's prior crime. Typically, we do crime grids. A crime occurs, whether it's a shooting, whether it's a sexual assault, depending on the business, whether it's random, whether it's an acquaintance crime, whether it's a crime committed based on proximity or location of vulnerable victims, or whether or not this is a random crime or some intrusion on the property that caused the issue. But this article literally is saying to plaintiffs' lawyers, we need not worry about crimes. Let's not worry about trying to find crimes. We want to be as creative as possible to show. And the bottom portion of it is the portion in bold. And I think that's the portion that I want the attendees to focus on the most. And this is what I could say, what I consider a compelling statement. And it's what drives me when I defend these cases. Trial counsel must be prepared to present to a jury any available evidence that will demonstrate that a defendant should have known that the plaintiff was likely to be injured and yet failed to take reasonable steps to protect him or her. And so here, the idea is we're going to cast the net as broad as possible. And we're not going to simply look at what's documented, but what's not documented. I will tell you this, just before you go to the next slide, Stephen. When I was in law enforcement, one of the things we tried to do in crime patterns is to try to gauge law enforcement activities with what we think what crime was going to occur based on reports. And so we had a study commission, and this is about 15 years ago. There was a study commission by my organization. And one of the things that they realized is you can't always rely on documented crime. For instance, well, there were 5 burglaries that happened in this community. No, not really. There were 12 burglaries that happened in that community. But the reality is that 7 people didn't report a burglary because maybe their insurance deductible was too high. And so they decided to just let it go. But you learn from neighbors. A neighbor told another neighbor, hey, this is what happened in my community. And the people didn't report it, but it didn't lessen the number of crimes that occurred. So when you think about that, perhaps maybe a business gets burglarized and you hear about it. And so maybe through word of mouth, maybe it's not a business on your street, or maybe it's not a business on your thoroughfare, but maybe in passing, you may hear that, oh, well, there's been a string of burglaries that happened 7 streets over, 8 streets over. And all of a sudden, there may be an indication is moving towards your direction. If a plaintiff's lawyer can find out that there were crimes being committed and you realize that there were other businesses that may have been several streets or even farther away committing, experiencing issues that you ultimately determine, that's going to be admissible. It's going to get in. It's going to get in and show that you should have known to take reasonable steps.
Wow, yeah, it's a little frightening out there. Hang on, everyone. Let's look at this next slide, Derrick, because we're asking ourselves, is it foreseeable, right? Can we forecast it? And you just talked about we have this responsibility that we knew or should have known, right? Understanding, taking reasonable steps to anticipate it. So you've laid out for us some things here that we need to consider when we're making that assessment.
Yes, and industry standards is a given. A community's crime rate is a given. General character of surrounding neighborhoods, that's something that's generally known. But what I will say is, if you look at number 4, the extent of assaultive or criminal behavior in an area or in a similar business enterprise, This is one that begs the question, even though I may not have crime, say, in my very small geographic nucleus, are other establishments that provide the services I do experiencing the same crimes, even if they're far removed, right? So your business, and we'll get to that. I won't jump ahead, but is my business the same kind of business that other businesses have exist that are experiencing crime issues? Another one, and the presence of suspicious persons will be discussed later. But I want to take also a look at number 6, and that is the particular or unique security problem posed by a business or premises design. That's not something that's really thought about as much. You'll be surprised, but that's a very important thing. For instance, does your business have blind spots? Are there areas in your business that may be more vulnerable to an assault on a patron than other places of your business? We get this a lot in cases where you have a detached parking lot that primarily serves as a parking lot for an establishment. And courts today have started, we're starting seeing more cases where courts are saying, if you have, say, a detached parking lot, and that detached parking lot is a parking lot that's primarily used for your patrons, you may be charged with making sure that it's reasonably safe, even though it's not necessarily a fixture to or pertinent to your business, right? Because that can be a situation where maybe the problems posed by your business design, something is detached, not close, or perhaps maybe the way your business is located. You're on a major thoroughfare where people can come in and out of your business. And it allows quick ingress and egress in your business. And so it may be very inviting to smash and grab or snatch and grab criminals. So those are some of the things that you have to look at that are not necessarily looked at initially, or not necessarily looked at generally when you're talking about foreseeability. And we'll discuss some other examples of that as we move forward.
Yeah, that's very helpful. And we've got not a lot of time left. And so I want to jump now into the post-incident assessment, right? So let's look at this next slide. He's given you a terrific list of questions. In the interest of time, Derrick, I'm going to jump over to this next slide. And so you take this kind of from a psychological perspective, which I think is really terrific. Can you talk a little bit about that for us?
Sure, I do. And post-incident investigation is about helping you as the organization come up with a way to fix what's broken. I cite 2 cases there in which, in terms of how to go about these things, you have to look at what the individual organization is aware of, what they're doing, and their desire. So, for instance, if you look at the second case that was cited, there was also evidence that management had received complaints from customers regarding suspicious vehicles and suspicious purchase in the parking lot, but did nothing about that complaint. The court is making aware that to them, that is sort of an incident. Even though it wasn't a crime, it was an opportunity to be aware. And so here you had a situation where the management was aware of concerns, but really didn't do anything to try to follow up on those concerns and see whether or not those concerns was something that could be mitigated. And then it escalated into having an incident where all of a sudden now you have a customer that has been significantly injured by a criminal. So that's one of the things when it says it starts with you internally. You have to care beyond the incident, essentially. You can't wait till an incident. You have to back it up a little bit and treat awareness like an incident. Have I become aware that there may be a problem? Have I become aware of a potential problem? And what steps did I take to address that before the incident that is in litigation took place? And so the courts are allowing plaintiffs to develop and present to a jury that you knew about some things, regardless of whether or not that was an incident that occurred. So we want to take a step back in management and really think about, what did I do before the incident? And could I have done something to forecast what potentially occurred or did occur?
And in this case, as you've highlighted here, I found this fascinating that, this kind of falls under the category, no good deed goes unpunished, right? But the
Exactly.
fact that this organization was escorting their employees to their cars after work raised the issue for the court that, hey, if that imputes to you knowledge that there could be a risk here.
Absolutely. Absolutely. And again, it goes back to the awareness. And that's one of the things that we're thinking about now. Not simply, the incident doesn't start with the crime. The incident actually starts preceding that.
Right.
When you first became aware of the possibility, now what did you do to address that possibility? And that's where your post-incident assessment starts.
Yeah, let's look at this next slide. You got another case here for us. It's a it's a Remington. It's a leasing facility, not really a hotel, but I think the outcome is very beneficial for everybody, right? Just to summarize it, is that this business was telling its employees to really not be transparent with their potential customers. And it just
Absolutely.
goes to show you today, especially, that kind of stuff is going to get discovered.
It is, and it opens the door for nuclear verdicts. And that's a presentation for another day. But that type of awareness and that type of knowledge could certainly open the door for a nuclear verdict when you have an incident on your establishment. And so, again, this goes back to, when it comes to mitigating these security and crime risks, everybody has to be on board with that. Mitigation cannot simply be something that the insurance company says we have to do to get a better premium. This is something where the court is saying, look, your management, the people that work for you, they are equally responsible for essentially helping mitigate these matters, and they didn't. So that's something that every organization has to be aware of, which is why we put that case in there.
Yeah, Derrick, we've got just a few minutes. So on this next slide, ladies and gentlemen, he has given you some things to consider when you are assessing the risk, right? Once you've done your situational awareness, once you've done your prioritizing, these are things that you need to think about when you're making your decisions on how to mitigate the risk, right? Let's look at this next slide. And this case, it's against La Quinta back in 1988, but I think it just reinforces, Derrick, your thought about how one size does not fit all.
Correct. And again, this is a case that's still a seminal case today. It's still cited by other cases, and the reasoning that the court used is still very influential. So I like to tend to use these cases because the actual reason presented by the appellate court is one that you should take note of. But what we did was we highlighted in bold one of the key statements in the case. A lot of times the responsibility turns on whether it was reasonably foreseeable that such attacks would occur in the absence of the precautions. And so what does that do? It creates a balancing act. If I don't have this precaution, would this event have occurred? And we talked about this a little bit. Everything is not one size fits all. Maybe you have a lot of cameras outside your organization. There was a period of time in the smash and grab era, at least in the state I'm in Florida, where criminals were pulling up to the sides of roads. They were getting out in all black. They were going and snatching objects from people, and people wound up getting injured. And so you would say, well, we have cameras out there. We have cameras out there. We have cameras out there. Clearly, the cameras were not a deterrent because the assailants were not there long enough for the cameras to be of use, or they were they were dressed in such a way where it pretty much diminished the value of the camera. So you have to look at what situation you're in after you're aware of who you are, what you do, and how you serve. And then ask yourself the question, if I have this security measure, is this security measure going to stop this kind of crime? If you are a lodging establishment and you have cameras all over the place, is that going to necessarily stop vehicle burglaries? Is it going to stop perhaps a robbery in the parking lot? Okay. If you have a food and beverage establishment and maybe you have cameras, say at the front of your door, or you have cameras monitoring the parking lot, well, is that going to be enough to say maybe stop a sexual assault on a patron, right? Or is that going to be enough to prevent a physical assault on a patron? And the more we're finding out, sometimes cameras work better in some businesses than they do others. So it's all a balancing act of determining what security measure is going to best protect against the vulnerability that you're concerned about the most.
Yeah, very helpful. Derrick, we're going to need to wrap up. So I just want to remind everybody, if we go to this next slide, that he's emphasizing these things again as in your post-incident assessment. So you've seen this slide before, but we're emphasizing that. On this next slide, I think it's important to point out that the court in this case, Derrick, it not only said you have a duty of reasonable care, but if you provide a remedy to your guests, a potential remedy, you had a duty to make sure, at least do some diligence about the quality of the service that's being provided.
Yes, and this is just a case in which a person that had diabetes went into a diabetic shock and eventually expired, and the hotel had retained a on-call service to come out and provide medical service to guests, only to find out that the company itself was owned essentially by, considered a mom and pop operation where there was no one there with any credentials to assess medical services that were being provided. And apparently they were involved in a prior incident. And one of the things that the court noted was this: if you're going to step into the foray of providing a service, you have to make sure that the service providers that you use are the type of people that can provide the service. We didn't put it on this slide, but I just wanted to let you know, this is often the common arguments that are made to defeat independent contract agreements that may exist between a business and a third-party provider. And that is simply this: if you're going to provide that service through a third party, you have to make sure that the third party is qualified to do the work and qualified to do and make whatever assessments or provide whatever assistance you're seeking from it, or else you're going to essentially be charged with the violation of that duty.
Yeah, that's crucial to understand that today. So on this next slide, ladies and gentlemen, Derrick's really strongly suggesting, he's done throughout, that we have to move from being reactive to being proactive. And of course, that's where the awareness comes in, and doing your assessments with the questions he's provided you. And then he's also on this next slide giving you some, in the proactive stage, encouraging you to do the things he's laid out for you there. Derrick, let's get to that, the next slide, which is the last piece. I know you've shared with us, we can't eliminate all risk. You've given us some great insight on how to mitigate risk. Any closing thoughts you'd like to share with the audience?
Just to share, all of you are seasoned professionals and working in various occupations that intersect with risk at some point, whether you are a lawyer, whether you're an insurance professional, whether you are the business professional yourself. And the main thing is you always want to think about, in terms of mitigating risk, is start with a broad perspective. How is this going to affect my business? How is this going to affect my organization if this risk materializes into an incident? And I think if you start with that mindset, then it opens the door to possibilities that you will look at that best mitigate a particular risk that affect your organization. So you kind of start with that mindset as opposed to starting with a closed mindset that, you know what, this hotel did it this way, this lodging establishment did it this way, so we're going to do it this way. This food and beverage establishment did it this way, so we're going to do it this way. No, let me take a step back. I'm aware of who I am. I'm aware of what I do. I'm aware of how people use my business and what they give to my business. Now let me ask myself the question, if this risk becomes an incident, how is it going to affect my organization? And you let that drive your mitigation strategies.
Those are terrific closing thoughts. Thank you very much for joining us today, Derrick. We really appreciate your time, and thank you to Hamilton Miller for allowing you to join us. Greatly appreciated. We hope to see you soon.
Thank you. I certainly appreciate it. Thank you for the opportunity.